The Department of Justice paid its first ever antitrust whistleblower reward. What insiders should know. The DOJ just paid its first antitrust whistleblower reward in conjunction with the U.S. Postal Service, and that's an important letter that was delivered. There's a million reasons why you should pay attention. The first whistleblower was given $1 million, and in contrast to the glacial pace that some of these whistleblower cases go, and sometimes the mail goes, this went at blazing speed. The payment was announced January 29, 2026 by the DOJ Antitrust Division and the U.S. Postal Service. According to the government, the whistleblower provided information that helped lead to criminal antitrust and fraud charges against EBLOCK Corporation, which resolved the case through a deferred prosecution agreement and agreed to pay $3.28 million in a criminal fine. So this program is no longer theoretical. This pilot program is real, it's funded, and $1 million went to the person for doing the right thing. It's producing seven-figure whistleblower rewards. I'm Jason T. Brown, head of Brown LLC, former FBI special agent, and in this video I'm going to explain why this first antitrust whistleblower reward matters, what actually happened in the EBLOCK case, how the DOJ antitrust whistleblower program works, and what insiders should look for if they suspect bid rigging or price fixing or other collusive behavior, and how this program changes the incentives inside companies. Why this $1 million antitrust whistleblower reward matters. For decades, criminal antitrust enforcement relied heavily on the DOJ leniency program or the False Claims Act. If the anti-competitive behavior extended to impact the price to the federal government and what it paid, then the False Claims Act, which deals with fraud against the federal government, could indicate that you could recover the differential between the inflated price paid and the price that should have been paid had there not been collusive behavior. So if the government paid $10 million extra due to price fixing, the damages could be trebled up to $30 million, with the antitrust whistleblower being entitled to receive up to 30% of that as a False Claims Act whistleblower reward. But pushing the False Claims Act aside, if the anti-competitive behavior didn't impact the federal government, then you look to the DOJ leniency program, where companies involved in cartel activity, that's collusive activity, could receive the significant benefit of essential immunity if they were the first to report the misconduct. So if the company conspired with others to fix prices, made a lot of money along the way, there's really no reward for reporting it except they were relieved of the consequences if they were first to report. That created what some practitioners called a race to report, so that way you can receive some coveted protections. Companies, when people with integrity would take over, would rush to report their co-conspirators before they were reported, because as the odd man out, they were the ones that didn't have to pay. But now with the new DOJ Antitrust Whistleblower Rewards Program, that changes the dynamics. Now companies are not just racing against their competitors to report, they're racing against their own insiders, who are now incentivized economically to report this with up to 30% of what the government recovers. These insiders are employees, former employees, executives, consultants, engineers, data analysts, people who have inside information. And anyone with original information about antitrust violations may now have this direct incentive to report it to the government. That changes the leverage inside organizations, and it changes timing. What happened in the EBLOCK antitrust case, according to the Department of Justice, they allegedly operated an online auction platform for used vehicles. In November 2020, EBLOCK acquired another auction platform identified in court filings as Company A. We've all used Company A before. DOJ alleges that after the acquisition, EBLOCK did not promptly stop collusive misconduct occurring on that platform. Between November 2020 and February 2022, individuals associated with Company A and Company B allegedly conspired to suppress competition in vehicle auctions conducted through that platform. The company tied that conduct to Section 1 of the Sherman Act, which deals with antitrust behaviors, and it's the primary federal criminal antitrust statute. But the case involved more than just antitrust violations. The DOJ also alleged there was shill bidding, and that's where this case becomes particularly important, because it shows how antitrust violations and fraud can overlap in the same scheme. Let me explain to you what bid rigging and shill bidding are. Bid rigging is a classic criminal antitrust violation. It occurs when supposed competitors secretly coordinate rather than compete honestly. Some examples include agreeing in advance who will win an auction, coordinating what the ceiling is, the maximum bids, dividing up the customers or markets, sharing confidential bidding information ahead of time. In the EBLOCK case, the DOJ alleges that individuals shared bidding information and coordinated on what the ceiling was for the maximum bids. That undermines the fundamental purpose of an auction in a free market, real market competition. But the government also alleged shill bidding. According to the DOJ, sophomore was allegedly used to place fake bids under the names of real dealerships without their consent. These bids allegedly drove prices higher for legitimate buyers. That conduct may raise fraud concerns in addition to antitrust violations, and it's an important lesson. Sometimes the scheme can trigger both competition laws violations under the DOJ pilot program and fraud charges. What potential antitrust whistleblowers should look for? Well, first of all, there's got to be a hook with the U.S. Postal Service, so you do need to allege it went through the mail. But many antitrust cases are uncovered by insiders, and the warning signs often appear long before regulators detect them. Some examples include the competitor sharing bidding strategies or pricing data, instructions not to compete aggressively in certain markets, even though intuitively that's a good market, agreements to divide customers, territories, or products, coordinations of bids and auctions or procurement process, or if you can recognize suspicious patterns in bidding outcomes, perhaps use AI to track this, or communication suggesting competitors are coordinating prices. When insiders observe conduct like this, it may signal certain violations in violation of the Sherman Act, like price fixing, bid rigging, market allocation, or other cartel behavior. That's collusive behavior, and they're criminal antitrust violations. Why is the U.S. Postal Service involved in all this? Some people, including myself initially, were a little surprised that this program was administered with the USPS, and yet it worked out so expeditiously. The reason is structural. The program operates through coordination between the DOJ Antitrust Division, the U.S. Postal Inspection Service, and the U.S. Postal Service. In the EBLOCK matter, the government noted that documents supporting the scheme were sent through the U.S. mail, and you're going to always need to allege a predicate that some of the misconduct happened through the U.S. mail, unless it was fraud upon the federal government, then you could use the False Claims Act. But the mail nexus helps establish federal jurisdiction in certain investigations. How the DOJ Antitrust Whistleblower Program works. Under the new program, whistleblowers who voluntarily provide original information about criminal antitrust violations may qualify for a reward if their information leads to criminal fines or recoveries for at least $1 million. If the whistleblower qualifies for an antitrust whistleblower award, the presumptive award could be up to 30% of the recovery. And in the inaugural award, they try to do close to 30%. The DOJ does retain discretion over the final amount, so you are at their mercy. The more helpful you are, the better chance you have of a big recovery. But the EBLOCK payout demonstrates something important. The program is active and is already producing a meaningful financial award. One of the questions we always receive are what retaliation protections are there for antitrust whistleblowers, and you should always consult with an attorney if you're concerned about retaliation. The Criminal Antitrust Anti-Retaliation Act, known as CAARA, CAARA, provides protections for employees who report potential criminal antitrust violations. These protections may include reinstatement, back pay, compensatory damage, and attorney fees. CAARA is enforced through the OSHA's Whistleblower Protection Program and process. Here's one of the most important lessons in any whistleblower case: timing. Timing is critical. Timing is often the most important factor. If an insider reports early, the government can investigate more effectively, evidence is easier to preserve, and the whistleblower may qualify for a financial award. But if someone waits, another insider may report it first, the company may run for leniency first, or critical evidence may disappear, and that happens more often than you think. In whistleblower law, primacy by being first often matters. The bottom line, the Department of Justice and USPS have paid its inaugural $1 million antitrust whistleblower reward. The case involved bid rigging and shill bidding tied to online vehicle auctions. It resulted in a deferred prosecution agreement and a $3.28 million criminal fine. And it sends and broadcasts a definitive message. The DOJ antitrust whistleblower program is active, real, and capable of producing serious rewards, and they want to hear from you, and we want to hear from you. I'm Jason T. Brown, head of Brown LLC, whistleblower law firm, former FBI special agent. If you have original information about price fixing, bid rigging, market allocation, or other competition fraud, or you're uncertain whether it's collusive behavior, the most important step is to evaluate the situation strategically, because in antitrust enforcement, the first person to report it may have the most strongest position. If you have original information about price fixing, bid rigging, market allocation, or other competition fraud, other collusive behavior, other anti-competitive behavior, you really need to speak to somebody who has a background in whistleblower law and protects whistleblowers themselves, like Brown LLC. You need to know your rights. There's a couple avenues besides the CAARA protections that will protect you, and we'll try to protect you if you work with us. You may have a $100 million False Claims Act case, so you need to know that, or you may be able to thrust it in the pilot program, which isn't indefinite. They're going to see if they're going to continue it. So wouldn't you like to continue it with some of your information that can lead to another $1 million reward? Thanks for listening. If you have any questions about whether or not your company is engaging in anti-competitive practices and you just have a suspicion, give us a call.